Hello everyone and welcome to today's Mondac webinar in association with McCarthy Tétrault, who will be reviewing Canadian employment law under the lens of 2023. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. But before I hand over to begin today's webinar, a housekeeping item. You can submit questions by typing them into the questions pane of the toolbar on the right-hand side of your page. The panel will endeavour to answer as many questions as possible during our Q&A session, but please do reach out afterwards for any additional information you may require. It's now my pleasure to hand you over to our panel to begin. Thank you.
Thank you, Dan, and welcome everybody to our webinar that we're partnering with Mondac again. We're very excited to do that. We have a great partnership with Mondac and happy to bring you today a whole suite of really topical issues that come up in our legal practice, not only now, but we're projecting that they're going to be important issues into 2024. My name's Tim Lawson. I head up our labor group nationally. We have a large labor and employment practice across Canada, where we provide advice to management side clients across the country in every industry. But enough about that. Again, we're excited to be here. We have a great panel, and I'll introduce each person right now. So we have Jess Woogler beside me. We have Pat Pengelly, Marco Fimiani. This is our Toronto panelist, and we have Emily Thibault from our Montreal office here as well. So we have only about an hour, and of course we're always ambitious about the material that we want to convey to y'all, and so we're just going to start right into it. And if we go right to the agenda, you'll see that we are going to talk about 5 different matters. So there's a lot here, but I think that if we touch on each one of these and give you the key highlights, the key takeaways from each of these items that are, as I said, topical today and important to you as employers, in-house counsel, legal counsel, I think we'll walk away from the end of today with, I think some good tips to take in back to the workplace. So without further ado, we're going to talk about workplace investigations, which we are doing a lot of, probably more than we've ever done, in part because there's a lot of legislative requirements that requires employers to conduct investigations, and there's heightened lens on employers' conduct in conducting those investigations. So I'm just going to turn it over to Marco.
Thanks, Tim. And yeah, that's right. As Tim said, there's really been an uptick in terms of the questions we're getting as well related to investigations, as well as the actual conducting of investigations themselves, in part because of legislative changes or amendments actually requiring or creating more onerous obligations on employers, particularly at the federal level, in terms of actually conducting investigations. So we want to just kind of go through a refresh in terms of things to consider when conducting an investigation or when going down the path of conducting an investigation. And so the need to investigate can really be triggered in a number of ways. The first can be when the employer actually witnesses or otherwise becomes aware of possible misconduct relating to an employee. And this idea of becoming aware can take various forms depending on the nature of the business itself. And so for some companies, the employer is an identifiable person who's on site at the workplace day in and day out. For larger companies, the employer may be further afield, and Canadian courts have held that where managers and supervisors are aware of misconduct that requires investigation, that knowledge will be imputed onto the employer. Another trigger to investigate might be, for example, receiving an oral or written complaint, whether from an identified person or from an anonymous source. The duty to investigate can also be triggered when the employer should reasonably be aware of possible misconduct. And so with this, there's almost a sort of duty around some diligence on the part of the employer. Really what this means is that an employer can't remain willfully blind to things like, for example, harassment in the workplace or allegations of harassment in the workplace. The employer may also have policies in place that automatically trigger an investigation upon the happening of some event. Most employers have some policies like this so that they can provide managers and supervisors with clear direction as to when to investigate. But there also might be some jurisdictions, and I'll use Ontario as an example, that require employers to have policies and programs in place regarding workplace harassment and violence, for example. The timing of an investigation is important. Delays may be interpreted as condemnation, so it's important that action take place as soon as possible. This is also important not only from a reputational perspective, but also the need to preserve that evidence. Memories do fade, and they can fade over time, or they can change after individuals have had time to think about or talk to others about the events that took place. For a unionized workforce, it's imperative that employers also follow any relevant collective agreement provisions regarding, for example, timelines, in particular union representation rights for meetings. So some collective agreements might require or might provide a bargaining unit member with the opportunity to have a union steward or union representative attend that interview meeting with them for the purposes of the investigation. And so you want to be mindful of all of those as well. Complaints should also be taken seriously, and so they need to be taken seriously, dealt with promptly, and handled in a way that's consistent with the organization's policies and the legislative requirements of the employer. And determining what you need to know and what you'll learn what you'll need to learn through the investigation runs its course. It's important to think about that at the outset of the investigation, so you can determine how many arms an investigation might take and how it might snowball from an initial question and might actually go on to have more than one witness, for example, how we're going to get to those other witnesses and how we're going to kind of manage that process. And oftentimes mapping that out to the best of your abilities at the outset of an investigation is advisable. If we can just go to the next slide, please. So in terms of best practices for managing a workplace investigation, I think the starting point is really to review the complaint, establish the purpose and scope of the investigation, and then consider how wide you want to cast your net or will need to cast your net in terms of interviewing witnesses. The next thing to think about is really who to appoint as the investigator and who will actually be conducting the investigation. And so more serious, high stakes investigations should really be conducted by trained workplace investigators or legal counsel. The actual nature of the complaint or the allegation being investigated may also warrant someone with specialized knowledge. So you think about maybe there's some sort of accounting allegation associated with like misappropriation of funds. Like you might want someone there with specialized knowledge or expertise investigating those types of allegations. So you'll want to think of prior involvement with underlying issues when looking for an investigator, the influence of management or persons implicated. So sometimes more senior officials who are being investigated, bringing this outside of the actual employer to someone with specialized knowledge or perhaps legal counsel is advisable. Less serious matters may also be investigated then by management, HR departments, a security department, privacy office. It really will depend on the nature of the workplace, but finding a method that's one, sufficient for the purpose of the investigation, two, economical, and three, confidential will also be things that you'll want to consider as you navigate down the path of choosing an investigator. For federally regulated employers, there's been some changes to the legislation under the Canada Labour Code and the corresponding regulations that actually implement and certain standards or requirements for choosing an investigator. And so we'll just want to be mindful of that there might be legislative obligations around who you choose as an investigator for the purposes of conducting the investigation. Maintaining confidentiality is key. It's really critical to ensure the effectiveness of the investigation, especially with interviews. And so before the interview, you want to determine logistics, location, and order of interviews. You want to be mindful of where you are conducting the interview. So the Tim Hortons close to the workplace that many other employees go to on a day-to-day basis for coffee or lunch may not be the most opportune place to conduct a confidential workplace investigation or meeting or interview with another employee regarding a workplace investigation. So you want to be thoughtful and mindful of that, as that can really have an impact on the efficacy of the investigation itself. You'll also want to consider privilege. And so labeling something as privileged and confidential does not mean that privilege automatically implies, but there are circumstances where an employer can conduct an investigation that is privileged. There's solicitor-client privilege, litigation privilege is another one. And when looking at privilege, courts and tribunals will really want to review the terms of reference to determine the purpose of the investigation. Consider whether the dominant purpose is reasonably contemplated litigation or legal advice. And again, you can't just stamp privilege and confidential and expect privilege, but you'll want to think about whether or not the investigation is inextricably linked to the legal advice, and if so, it can be considered privileged. Another thing to consider from a privilege standpoint is if you're looking at assessing certain, like a workplace audit, for example, or navigating down a path of retaining a consulting firm or with some expertise in a particular field regarding an investigation, you might want to actually do that through counsel in order to manage privilege in connection with that audit or through that assessment or investigation. Otherwise, most of that will actually be producible in the event that things sour or litigation does commence. So just something to be mindful of. If we can go to the next slide, please. So I'll move through this slide pretty quickly, but really just drafting investigation reports. They can take a whole, I've seen many forms in my time here. And so depending on whether you're federally or provincially regulated, there may also be statutory requirements for the contents of any written report. And so, for example, the Canada Labour Code regulations now require any report regarding a workplace investigation to include a general description of the occurrence, their conclusions, including those related to the circumstances in the workplace that contributed to the occurrence, and the recommendations to eliminate or minimize the risk of a similar occurrence. A collective agreement, for example, might also impute certain requirements on the employer in terms of what is included in an investigation report. And you'll also want to consider what needs to be distributed to the parties, to those who are parties to the investigation. Do I need to provide them with the investigation report, or just the outcome of the investigation and any corrective action, for example? You'll also want to consider, as you're looking at the investigation report, what the nature of the misconduct actually is and what kind of position does the employee occupy. All of that will be relevant to the decisions that you make associated with the investigation in terms of acting on the investigation and the report that comes out of it. You also want to, if a third party was retained to actually conduct the investigation report, I do recommend that you also consider conducting your own, if it's a termination related recommendation, your own just cause analysis to assess whether or not the misconduct is sufficient for cause to terminate the employee's employment. Something to be mindful of. You also want to consider, are there appropriate remedial actions such as coaching or training that might be permissible or make sense in the circumstances? And if so, what you want to do with that. You also want to anticipate challenges that may stem from the findings. And so some of these are like workplace dynamics, including the potential reintegration of the complainant or also the respondent in the workplace themselves. Can we just move to the next slide, please? So the consequences, the main consequence of an improper investigation is really that it may impact on the employer's ability to defend the action that it's taken as a result of the investigation. And so it may prejudice its position for discipline, for example. It may also prevent the employer from relying on the findings of the investigation. And there's a whole host of examples of case law that the decision of the employer fails on the part of the investigation that took place itself. And so there's an example from 2022 in Ontario, this Routledge case that's on the screen in front of you, that is really an example of how workplace investigations can go wrong, as I put it, with the court criticizing the nature of the investigation. And so in this case, the employer had received complaints that its executive director became romantically involved with a contractor who began reporting to her. And after several complaints, which the employer sat on, it decided to conduct an investigation and used an investigation firm associated with the law firm that acted for it in the case. And so that was particularly problematic in this case, since the employee was informed that the investigation would be coordinated by an independent third party, but that firm wasn't necessarily independent. The investigation also began before the employee was even informed of it, and the investigator also failed to take prudent steps to keep the investigation confidential. And so in this case, they actually conducted the interviews at the nearby Tim Hortons, where some of the employer's 150 employees took their breaks and their meals frequently, day in and day out. And ultimately, in this case, the employee was awarded an additional $50,000 in bad faith and moral damages based on the nature of the investigation itself. And so you'll just want to be mindful of what kinds of representations are being made to employees through the course of the investigation, about the investigation and the process that will be followed. So if you have a process for investigations, you'll want to be sure that you're actually following that process. And with that, we can move to the next slide.
Thank you, Marco. Yeah, so still on the topic of workplace investigations, I thought I could convey a recent case law that is topical that had made the headlines amongst the employment lawyers last year, and it relates to a Christmas party. And yeah, this may be the season for workplace investigation. So the situation started as a result of a Christmas party. A mechanic was terminated because he refused to participate in an investigation concerning events that occurred at a hotel following the company Christmas party. And the events in questions involved several employees, drug consumption, and sexual activity in a hotel room at the hotel. The next Monday at the office, it was kind of awkward, and the employer had no other choice but to shed light on the incidents because employees were no longer comfortable to work with the employees who partake in this activity at the hotel after the Christmas party. And so the employer began the investigation and met with this employee, and the employee, the mechanic, refused to participate in the investigation. He actually took a confrontational stance and argued that the events were private in nature and that the employer had no right to question him about events that are not work related. And eventually the employer terminated the employee for his lack of cooperation. Now, the arbitrator that was called upon to adjudicate on this case concluded that, well, the employer here in this instance had right to initiate an investigation into the private events that occurred outside the work environment because of the direct link with the work atmosphere. And the employee was, as a result, required to cooperate in the investigation. And this is actually a legal duty that is provided for in the Civil Code of Quebec. And so this is a good case that illustrates that to a certain extent, the legal duty of loyalty can supersede privacy rights during workplace investigations. And now you can move on to the next topic.
Great, thank you, Emily. Thank you, Marco. It certainly is the case that holiday parties do create an inventory of cases for us, sadly. Every year, I think it's the same thing. And, you know, there's lots of reasons to hold them, but I think there's lots of reasons to, you know, make sure that you've you know, said the right things to employees about conduct and really done some pre-planning before, you know, the bar opens and the holiday parties start. It's just, we say this every year. Just for those who are not in Canada, Tim Hortons, by the way, is an iconic coffee shop in Canada. So that's an important point I think I wanted to raise. We do have a question from just related to this topic, and maybe Marco, I'll ask you. And the question from one of the people in the audience is, can we record the interviews done in the investigation? So that presumably is, can the employer record the interviews done in the investigation with the involved employee's consent?
And so the answer is really, it depends. You'll want to be mindful of which province you're operating in and if there's any sort of privacy legislation at play and what the requirements of adhering to that legislation would be. But it is possible to record. But you want to be sure that you set the expectations of that in advance of the interview taking place. And so that goes for the employer as well as for the employee. And so if we're not intending to record and we don't want the employee to record it, we'd also want to be mindful that we make that clear to the employee as well.
The flip side being, employees often want to record and sometimes they don't tell you.
Yeah. So
it's pretty important at the start of an interview to ask the employee to ensure that they're not recording the investigation.
That's right. And typically, in the course of an investigation at the outset, you'd say something to the effect of, we ask that you not record this investigation, and you're entitled to take notes if that would be of help to you ultimately. And just make sure that you set those expectations clearly in writing, and those form part, and that introduction also forms part of your notes from the purpose of the meeting as well. It'll be important to document that.
And the audience member just mentioned that they were operating in Ontario, so the answer to the specific question is yes, you can record, but we would do it with consent of the employee.
That's right.
Okay, so let's move on. Now we're going to enter topic number 2. age-old accommodation cases issue, which is so topical. We deal with it every year, and it seems to be one thing that our clients are always asking us about because it is so germane to what employers do on a daily basis. So I'm going to turn it over to Jess.
Thanks so much, Tim. Good morning, everyone. Thanks again for joining us today. So jumping right in, working from home and flexible scheduling have become and continue to be a common issue that many employers continue to grapple with. And the shift away from work from home arrangements during the pandemic in some sectors, and employers implementing return to office policies requiring employees, for example, to work a minimum number of days per week, often from speaking with clients and from what we've seen, results in employers receiving requests for accommodation. And those accommodation requests, when you receive them, when you are evaluating those requests, really need to be tied to one of the protected grounds under applicable human rights legislation. So two of the most common grounds in the context of return to office that we are seeing is in relation to disability and with respect to family status accommodation. And while the COVID-19 pandemic has changed many things in the workplace, the accommodation process that employers should follow when they receive a request for accommodation really generally has remained the same and should be assessed on a case-by-case basis. So typically, once an employer is aware of an employee's need for accommodation, the employer should obtain relevant information about the employee's restrictions, the needs, and to determine how the employee can be accommodated through changes to the workplace or working conditions up to the point of undue hardship. So for example, an employee who may want to work from home to save time or money associated with commuting and childcare, although an employer may consider extending a remote working arrangement in that instance, the human rights legislation generally does not entitle an employee to continue working from home merely based on personal preference. However, human rights legislation may be engaged where the employee demonstrates that being required to return to the workplace would result in a real disadvantage, for example, to the parent-child relationship and responsibilities that flow from that relationship. So for example, protection under applicable human rights legislation may crystallize if returning to the workplace would put the employee in the position of having to choose between working and caregiving because of an absence of reasonable childcare alternatives, for example. So when an employer, when these accommodation requests related to an employee's family status, the employer or elder care obligations, for example, employers are in fact permitted to, inquire, ask questions about the nature of the accommodation need and whether alternatives have already been explored by the employee. And that's an important part of the accommodation process for employers, and in this context of returning to office and working from home and flexible scheduling. So, for example, you might want to ask, on what days and at what time of the week that the employee seeks to be accommodated. Are the family status obligations indefinite, or are they for a set period of time until they can figure things out? And are there, for example, special circumstances regarding the family member needing care? So if an employee is prevented from meeting job requirements for a reason that is related to a code ground, then the employer must look at whether that requirement is in fact reasonable and what we call a bona fide occupational requirement, or in other words, is in good faith or genuine. And this assessment includes determining whether the rule was designed inclusively and whether it would be possible to accommodate the employee without causing undue hardship. So just go to the next slide. So we're seeing more and more case law come out with respect to the concept of intersectional discrimination. And that concept really recognizes that people's lives involve multiple interrelated identities, and that marginalized and exclusion based on protected grounds may exist because of how these identities intersect. And it can actually make the accommodation process in cases a little bit more tricky for employers to sort of work through, and that requires some extra attention to these cases. So, applying that to the concept, I think, for example, an employee who has childcare responsibilities and a physical disability, they may have a greater difficulty meeting certain workplace requirements than they would if they only had one of those, issues related to a protected ground. And so when the employer receives these type of accommodation requests, they really need to be tuned into the different grounds and how they intersect and the cumulative effect of those grounds. So there's an interesting case, it's noted on the screen there, Tarek in Canada Attorney General 2023, Federal Court of Appeal 135. And in that case, an employee filed a grievance after her work from home arrangement was not renewed. She claimed that the employer discriminated against her based on her religious beliefs, family status, disability, and the combination of these factors. Her grievance was denied on the basis that there wasn't enough and sufficient evidence to show that she actually required the accommodation and that they weren't more so mere preferences. She sought judicial review of the denial of her grievance, and the court actually agreed with the board that had denied her grievance. And with respect to the intersectionality point in particular, the court really looked at the board's consideration of the factors that she was relying on in the grounds to see if the board looked at each one individually and then looked at the intersectional relationship between those grounds and the cumulative effect and whether or not, sort of the accommodation that they were looking for and whether or not they had met their obligations under the applicable human rights legislation. So it's a really important point to take note of, that when employers get these type of accommodation requests, that they are taking a look at each individual ground, but then also how they intersect and then how that can be accommodated in the workplace, so that they're not tripping up on these type of accommodation requests. So we'll go to the next slide. And what we've been seeing also in the last year, and what we'll probably continue to see, we've seen a trend in decisions from human rights tribunals generally rejecting allegations of a breach of human rights legislation in relation to vaccination accommodation cases. That being said, we have seen a little bit of a different take with labor adjudicators, where they have ruled in favor of employees in certain circumstances. What the case law does suggest, though, is that where an employee relies on a medical condition or a disability to request accommodation in relation to vaccination requirements, the case law suggests that that medical evidence must not only identify the disability within the meaning of the applicable human rights legislation, but also explain how that disability prevents them from being able to receive the COVID-19 vaccination. Adjudicators have set up a pretty high bar with respect to this type of evidence. And with respect to creed, which is another common ground that employees will rely on when they're requesting accommodation, we have seen human rights tribunal case law suggest that beliefs in informed consent and personal autonomy in medical decision making, even if they are in fact sincerely held beliefs, they do not fall within the meaning of creed, for example, under the applicable human rights legislation. However, this is where we're seeing a little bit of sort of a dichotomy in the sense that arbitrators have ruled in favor of employees in certain circumstances, objections to vaccines on the basis of creed where they have a sincerely held belief. And those cases were primarily tied to the fetal cell line basis for their religious convictions. So some key takeaways. So we'll just go to the next slide. So key takeaways and best practices when you're dealing with employee accommodations. So you want to make sure that you have clear policies in place in terms of return to work and accommodation in relation to those, return to work and return to the office and in-person working arrangements. You want to train your managers to address requests for accommodation in accordance with applicable human rights legislation and engage in dialogue with the employee and the collection of information, and the fact that employers can't rely necessarily on their third-party adjudicators if that is what they are relying on to assess the request for accommodation. Confidentiality with respect to the request is critical when you're dealing with these, sensitive medical information and other types of information that the employee is disclosing about their personal, the personal nature of their issue. And with respect to the type of information, you want to make sure that you're getting information so that you understand the restrictions that the employee is subject to. So if you're not getting the medical documentation, for example, that you're required to know the restrictions in the workplace and follow up and continue to push on that point. And finally, document. I think this is a constant and topic that we flag for employers. So documenting the process, documenting the steps that were taken, what was looked at, and that will be necessary to show that if you do reach the undue hardship threshold, that you've gone through the process and you can establish that. And so we'll go on to the next slide, next topic.
Great, thanks, Jess. So a lot to unpack there for sure. As I was thinking about it, it was just popping a lot of different issues, and I was just looking at the time going, that's just 10 minutes, and we could talk about that. We have webinars on this for hours. So again, sort of apologies about the 10 minutes on that topic, but it's a top one. We thought we'd bring it to your attention again. Sort of connected to that, particularly the COVID piece that you were talking about in accommodation is what Pat's going to talk about, which is organizational change. I mean, we got a post-COVID world, we have economic slowdown, we got high inflation, we have companies needing to make a lot of changes kind of rapidly to respond to the economics and the remote work environment and et cetera. So without further ado, I'll let you address those issues, Pat.
Yeah, thanks very much, Tim. And you're right. So the main reason we put together this segment of our presentation is because we're seeing this, right? And any large organizational change can be a critical mandate for any business, and they can also be challenging to navigate. And as Tim mentioned, as we've seen in the past 3 years, what is normal now, even taken for granted. Things like hybrid work or remote work, that was pretty much out of the ordinary, 3 years ago. And as employers continue to work through, dips in the economy, talent shortages, considerations about, their real estate footprint and so on, whatever the reason, whatever the impetus, embracing organizational changes now, it very much can be a business necessity for employers. So what I'd like to talk about is just 3 high-level themes today, being growth, downsizing, and changing course, and some of the issues and considerations that arise in those sorts of scenarios. So starting with growth, growth may require organizational change as a business necessity. As an employer grows, it may need more space for both staff and for its operations. But conversely, on the theme of coming out of the pandemic, a business that operates primarily in an office setting, may be in the process of again, reconsidering its real estate footprint, assessing various options such as increasing its hybrid workforce or remote workforce. Another example, an employer may incorporate new technologies that automate job duties, and as a consequence, significantly and permanently alter an employee's job duties. Similarly, change can also occur in response to acquisitions where new hierarchies and new reporting structures are imposed on employees post-closing. And something to think about is if substantial, unilateral changes to jobs are carried out, there are important legal and business considerations for employers, to think about. Do these changes in the aggregate have a real or perceived detrimental effect on an employee's job? It's important to think about the cumulative effect of these changes, in the aggregate, especially when assessing issues such as constructive dismissal risk, which is an issue that we are constantly advising on in the context of change. Periods of growth are also opportunities to ensure that an employer's workplace policies, their employment contracts are up to date and compliant. So there's an opportunity there as well if you're bringing in new people. And so that's sort of growth in a nutshell. So I'll move on, just given our limited time here, to downsizing. If an employer makes the decision to downsize, there are, again, a host of legal, business, reputational, and other considerations that are typically assessed And we know that downsizing can happen, on a macro scale, like a reduction in force, across several jurisdictions, or, these changes can happen on a micro scale, like fine tuning an employee's day-to-day work responsibilities. So when an employer is asking itself, what do we want to change? It should also ask, what are the legal obligations or potential legal liabilities that may be triggered by such changes, and further, what are the source of these legal obligations? For example, are there contractual terms in employment agreements that we need to be mindful of, particularly termination provisions? Are there legislative requirements that we need to navigate, for example, under employment standards legislation? And a particular example is, if we're undergoing a large organizational change, does it trigger, mass termination obligations, which are different than your standard statutory obligations when it comes to termination? On that note, what are the potential associated termination related costs under statute, potentially under contract and common law? And how can those costs be mitigated? Could we offer employees a working notice period that would help mitigate those costs somewhat? Similarly, are employees who will eventually be exited, are they going to be needed for a transitional period as a business changes? And are incentives being considered to create, buy-in from those employees to stay on for that transitional period? So, a host of considerations sort of coming out of the overall issue of downsizing. I'm going to move on now to changing course. Compensation changes. It's important to think about, again, the cumulative effect of these changes, especially when you're considering any potential constructive dismissal risk, because that can very much be a tangible issue you're going to need to grapple with. Return to office. Jess has gone over some very relevant issues that employers need to consider when bringing their folks back to the office. So I'm not going to repeat the useful points that she's raised. I'm going to move on to an issue that is interesting and we've been seeing recently, which is the issue of workplace relocation. I think this one's quite relevant in this environment. It's been something I've been seeing, and it brings with it a number of questions. Will terms and conditions of employment remain the same if an employer is moving its workforce to a new location? Do employees, currently receive travel allowances or travel benefits? Does it make sense to change those entitlements, with the new move, or introduce other new incentives? How far is the relocation, and where do employees actually reside? Because certain employees may be impacted differently than others when it comes to a workplace relocation. Is the proposed new location accessible by public transit? What is the current location? Is there going to be a change there that you're going to need to consider? So again, providing advance written notice of a significant change like a workplace relocation can reduce potential liability. It can also create a hurdle for employees who may be considering making a claim as a result of the change. So really, there's again a host of issues that for employers to consider if they're making a decision like that. Another point that relates to changing course, modifying schedules and work hours. So if schedules are going to be modified, if work hours are going to be modified, an employer may receive requests for accommodation, for example, for a schedule change on the basis of family status. And again, Jess sort of touched on some of those relevant issues. And you may need to deal with those requests in accordance with your existing accommodation policies. So with that, I'll move on to the next slide, which is, why does this matter? I think at a high level, it matters because these sorts of changes can be very expensive and perhaps surprising for employers. So you're going to want to consider, again, any contractual obligations that could be triggered with a significant change, compliance with applicable legislation, like especially employment standards legislation, as well as human rights considerations. And when it comes to employment standards legislation, I think it's worth noting that the Bill 79 recently received royal assent in October. and it provides further protections for employees under the ESA. In particular, mass termination entitlements are expanded will be expanded to include remote workers, because we know that under the ESA in Ontario, employees are eligible for enhanced notice of termination or pay in lieu of notice if 50 or more employees are terminated at an employer's establishment within a 4-week period. And the definition of establishment is going to be changing, and it's going to include an employee's private residence if the employer performs work in their residence and does not perform work at another location where the employer carries on business. So really this means that employees working remotely would be included in the head count for mass terminations and would be eligible for the same amount of enhanced notice as other employees sort of falling under that umbrella. So it's something to again consider if a reduction in force is on the horizon. So I'm quickly going to move on, given our limited time here, to just some quick key takeaways on the next slide. So at first point, have a recruitment and retention strategy. Does this significant organizational change warrant, for example, incentives to retain employees in order to provide transitional duties, the point mentioned earlier? Document your discussions, and this includes providing written notice of any future changes to employees. Review your employment agreements regularly, especially if you're bringing on new folks. Again, consider if you're going to be unilaterally changing the terms and conditions of your workers' employment, consider the cumulative effect of these series of changes on your employees, and provide, notice and clear communication in writing, and so on. So I'll leave those points with you and move on to, I believe, our next slide, Marco.
Yeah, and just before we get to Marco, when Pat says it can be expensive, just bear in mind that the Canadian jurisdiction is probably one of the most expensive jurisdictions on the planet for severance payments, right? For employees. We've really become a very expensive place to terminate employees. So the risks are high if we don't look at contracts and policies. And one of the questions that came up from one of the audience members is, drilling down to the specifics is if we have someone that we hired on a remote contract, and we want them to return to the office now, we get that a lot, right? Because offices are opening up, and people might have lived in in British Columbia. They want to come back to Ontario, and the issues are important to look at the policies that you have in place, the contract you have in place, to see if they allow for that ability, the employer to require the person to return.
Yeah, it's a great point, because in certain sectors, you see it in the tech sector, employees who were hired over the pandemic, from a recruitment standpoint, having a clause about remote or hybrid work was important to get talent to work for you. So if you're going to be dealing with a clause in a contract that says this employee can work remotely, then you may be dealing with a potential breach of contract claim, which is something that you'll need to navigate, again, depending on the specifics of the policies or the contracts that you're dealing with. Conversely, if in the absence of a clause like that, if an employer has a clear written policy that gives it the discretion to bring back its workers, then simply providing written notice and sort of advance warning of the change can very much mitigate those sorts of issues.
Yeah, in other words, I always say this, that notice can solve everything.
Yeah.
If you don't have something in your contract which allows it, as long as the notice is long enough and you're clear that at the end of that notice period, if you don't comply with the return to work, then your employment is going to be terminated.
Yeah.
Right. Okay, class actions. Now this is a very important topic.
Okay. Thanks, Tim. And so we can just go to the next slide. And so what we're hoping to do today, given our limited time, is just go through a quick overview of class actions and employment laws. We're seeing an uptick really in terms of class proceedings being brought in connection with employment-related matters across Canada. And so I just want to touch a bit on class actions, the involvement of unionized employees and class actions, and then maybe talk through some of the different categories of class actions we're seeing, as well as some of the risks associated with class proceedings. And so a class action is really a form of civil action where one or a few plaintiffs can sue a defendant on behalf of a larger group of people who can then claim the same type of loss from the same defendant. And so instead of separating or having separate lawsuits or having each plaintiff named in the case, which in some cases can be thousands, the representative plaintiff can really pursue the claim on behalf of a class. And to do that, in order for a class action to be heard on its merits, to do that, it really has to be certified as a class proceeding. And so certification really gives the representative plaintiff the authority to move the case along on behalf of the defined class. And when you think of the goals of class actions in Canada, at least, the pillars of a class action are really threefold. It's one, access to justice, two, judicial economy, and three, behavior modification. And so I just want to point to a recent case, a helpful decision for employers where the Ontario courts actually decertified a class proceeding on the basis that it no longer fell within those pillars. It really made no sense to actually proceed forward as a class proceeding. So in this case, there was a misclassification class proceeding brought on behalf of 69 independent contractors who were claiming that they were actually designated as employees in terms of their status. And so Ontario, being an opt-out regime for class actions, had 66 of the 69 employees opt out. And after the court initially certified the class proceeding, the court even raised concerns in its decision to suggest that whether the remedy being sought by the plaintiff would be seen as beneficial by the class members, or whether their financial interest would be actually hijacked by the claim as opposed to being advanced by it. So of the 69 proposed class members, 66 opted out, presumably because they enjoyed some of their tax benefits of their independent contractor status, as opposed to being categorized or designated as an employee. Of the three remaining, one had deceased, the other one couldn't be located, and so there was really one individual left that plaintiff's counsel was pursuing this class proceeding on behalf of, and was really steadfast on moving the case forward as a class proceeding. And ultimately, the court decertified the class proceeding because, as you can imagine, a case involving one employee or one individual, in this case an independent contractor, no longer really fits within the buckets or pillars of a class proceeding, and ultimately actually imposed a significant cost award against plaintiff's counsel in connection with that matter. In terms of unionized employees and class actions, which is a topic that comes up pretty often, I mean, class actions are really a tool for, I'll say this with the caveat, non-unionized employees to assert their rights because they aren't collectively bound the way that unionized employees are. And so as a general rule, courts have really held that if a dispute falls within a labor board's jurisdiction, unionized employees cannot seek remedies through a class action. However, like any general rule with the law or anytime you talk to a lawyer, there will always be some exceptions. And so there may be some scenarios in which unionized employees will be able to bring class actions or be involved in a class proceeding involving matters related to their employment. And so to determine when that might be possible, the court really looks at and analyzes the essential character of the dispute. And so there is a case out of one example I usually use is a case out of British Columbia from the Court of Appeal a few years back, where a class proceeding involving a dispute over post-retirement benefits of unionized retired public servants was certifiable as a class proceeding. And really, these post-retirement benefits predated the collective agreement that involved these individuals. And so really, the character of the dispute related to matters that weren't captured within the scope of the collective bargaining agreement. And so there are circumstances where unionized employees may be able to actually be involved in a class proceeding involving their employment, but there are many circumstances where they'll actually be barred from doing so. So we can just move to the next slide, which I'll turn over to Emmy.
Thank you, Marco. Now, on the topic of class actions, I would say they're not as frequent in Quebec. And the reason for that may be that there is a robust legal framework set forth under the Act Respecting Labor Standards that is oversaw by the CNESST. And for those who are not familiar with the CNESST or yet to collide with the CNESST, this is a governmental body that oversees the application of several pieces of legislation in Quebec, and it includes the Act Respecting Labor Standards. And so this act contains several complaint mechanisms, and they're all free of charge. And so what the complaints are, and especially the pecuniary complaint, what it entails is that the CNSST can claim on behalf of employees any violations to the Act. And the CNSST has the power to broaden the scope of any investigation should they find that it looks to them that this is a generalized HR practice prevailing at the employer's place. And I'm happy to give you an example as to how the Act respecting labor standards can result in very costly situation for employers. And the situation is dates back to 2019 and involves the Church of Scientology. And so in this case, there was an investigation. It started with one employee's complaint. The employee claimed that he was not paid pursuant to the minimum wage. And so an investigator from the CNSST was called upon to look into the situation. The investigator then found that it looks that at least 62 employees were not or had not been paid pursuant to the minimum wage. And so what the CNSST did is they eventually sent a claim to the employer asking for nearly 1 million in unpaid wages. And so this procedure went before the civil courts. And again, this was all free of charge for the employees. All they had to do is one employee filed a complaint and eventually covered 62 other employees. So, yeah. And I think now we can go on to the next topic that is Quebec related.
Thanks, Emmy.
Oh, okay. Sorry, you want to cover this one before?
Yeah, just cover a few more pieces on class action. So just really quickly, I want to just touch upon the common types of claims that we're really seeing in the class action world, if you will. And so really, what I'll do is kind of categorize these into three big buckets. And so the first bucket is really denial of pay and benefits. And what these are really your employment standards-based complaints. So the basic entitlements of employment for employees. And so we're seeing unpaid overtime, vacation pay, errors calculating pay, allegedly unlawful deductions from pay. And that's really what's captured within this first category. The second category is misclassification, and there's the most prominent being this independent contractors versus employees, but we're also seeing manager-based misclassification cases, and they're coming up more often than not. So managers, where someone's a manager in name only, but really the regular duties of their role are really more non-managerial in nature, and so therefore asserting that they're entitled to things like overtime, which in certain jurisdictions managers are actually exempt from. The last category is a bit more contextual, I should say, in that it's harassment and discrimination, and we're seeing more and more class proceedings being brought under this umbrella, and for the systemic failure to prevent harassment or discrimination in the workplace. And so there were some high-profile cases in the federal sphere regarding, for example, the RCMP. And then we're also seeing some cases like there's the Lewis versus WestJet case that you'll see on your screen there. And so in that case, initially the British Columbia Supreme Court declined certification, but ultimately it was certified at the British Columbia Court of Appeal. And so the plaintiff had alleged during their employment that she had observed and experienced a range of inappropriate conduct, largely from pilots directed towards female flight attendants. And then WestJet implemented various policies to promote a safe and harassment-free workplace. And the representative plaintiff ultimately claimed a breach of contract, which was interesting given the nature of the dispute, for a systemic breach of failing to provide a safe workplace free from harassment. And so their position is really that they contracted for a workplace that was free and safe from harassment, and the employer, in this case being WestJet, did not meet their end of the bargain, and that's what they're bringing this class proceeding on behalf of. And the British Columbia Court of Appeal has actually certified that proceeding. So if we just move to the next topic really quickly, I'll just identify some of the areas of risk associated with class proceedings. And so obviously the initial one being an adverse decision and what that can do. I mean, these are big cases involving can involve a multitude of employees or different entities, and so they can have a significant financial impact on employers in terms of the remedial relief claimed. Class proceedings are also public decisions, and with that comes a reputational risk associated with that. And so it can be in connection with like alleged unpayment of certain entitlements under their employment contract. But think of in the realm of, we've seen in, for example, in hockey in Canada as of late, many class proceedings being brought in connection with allegations of harassment and sexual harassment in particular, and the reputational impacts that can have and may have on an organization more generally. It could also lead to be the impetus for unionization efforts. And so employee concerns of unpaid wages or unfair pay practices can be, in some cases, precursors to unionization. And so when plaintiff's counsel mobilizes a group of employees in a relatively high public profile claim, it may make them an organizing target, or may shift attention to them as an organizing target. There can also be an impact on other employees who aren't part of the class action, but are still part of the same, employed by the same employer. And so class actions can be focused to, for example, a specific category of employees in a workplace. And sometimes the policies at issue in connection with those employees also apply to other employees in the workforce. And so figuring out the strategy around managing and navigating some of those questions in the midst of a class proceeding can be challenging. And so it involves a lot of strategic thinking and being mindful and thoughtful about process. And that kind of relates to the hindrance on organizational change and how it can impact on some of the organizational changes being planned. There's a likelihood of similar claims from other employees, maybe not related to the class proceeding, but on the exact same issue proceeding at the same time. Or you might have copycat class actions, or the domino effect, where the same claim is being brought on behalf of another category of employees, usually by the same plaintiff's counsel, involving the exact same issue as was brought in the prior class proceeding. So these are all things to be mindful of, and some of the risks associated with a class proceeding. The very last piece I'll say is just class proceedings are public, and so too are settlements associated with class proceedings. And so those settlements have to actually proceed through the courts. And so you have to be mindful of the impact that a class proceeding can actually have on the organization from a financial as well as a reputational perspective. And with that, I'll turn it over to Emily for the final piece.
Thank you, Marco. I would like briefly to touch on a very heated subject in Quebec at the moment, and that is the notion of establishment under the Labor Code. And the notion of establishment under the Labor Code is of the utmost importance as it relates to anti-SCAP provisions and restrictions to consider in the context of a strike or a lockout. And as you will see, the Superior Court disagrees at the moment as to whether or not an establishment also covers teleworking situations. The first case we will discuss is Group CRH Canada versus the Administrative Labour Tribunal. And the facts of the decision are pretty straightforward. An employer runs a cement plant with 130 unionized employees. A lockout was declared, and the union claimed that the employer breached the labor code because it used the services of non-unionized remote workers who were not managers during the lockout. And the Superior Court held in this specific decision that the notion of establishment does not include remote employees' homes. And it clarified that equating a remote employee's home with the lockout location is impractical, not reasonable, and in addition to raising privacy concerns, because it would allow investigators to visit private residences to ensure the compliance of the labor code. And then 3 weeks later, in a very surprising turn of events, the Superior Court went on to acknowledge the notion of deployed establishment, and that was in the next decision, the Novago case. You can turn on to the next slide, please. Thank you. Again, facts are pretty simple. This is an expired collective agreement. It involves union-led strikes across multiple establishments of the employer. The employer again faced allegations of breach of the labor code because it used the services of remote workers. And in this decision, the court upheld the first decision rendered by the Administrative Labour Tribunal and recognized the evolving understanding of a deployed establishment, which encompasses virtual workspaces. And it further emphasizes that remote work should not circumvent the labor code's provisions related to strike and that a restrictive interpretation of establishment is no longer applicable. And therefore, in this specific case, the employer was found to have breached the labor code. Interestingly enough, in this decision, the privacy concerns on which primarily hinged the other decision were not discussed at all in the second decision that was only rendered 3 weeks after the first one. And so as you can see, the state of law remains unclear as to whether or not the concept of establishment during a lockout or a strike includes an employee's private residence. But we will soon find out, because the Court of Appeal will clarify the question in the first decision, the CRH decision. I believe the case was heard in July of this year, so this decision should be rendered anytime now. And also, to bring things into perspective, it is also worth noting that at the end of 2022, the Health and Safety Act was amended so as to include the notion of an employee's residence for the purposes of health and safety obligations incumbent on an employers. All this to say, the year of 2024 should be interesting, and we'll be monitoring very closely the evolving concept of establishment. Thank you.
Great, thanks, Emily. And that's an issue that's not restricted to Quebec. There's some legislation in Ontario that deals with, it's not called deployed establishment, but it relates to mass termination obligations and where people are located for the purposes of calculating how many people are in a certain geographical area for the purposes of determining whether it's a mass termination or not, right? And we have a blog on that topic as well. But in the interest of time, I just want to thank the panel for spending an hour with me today, and thank you, audience, for spending an hour with us. Hopefully it was useful. Again, we scrolled through a lot in our ambitious agenda, but I think there's a lot of takeaways that can come out of this. So just for the audience, we have a whole suite of blogs and newsletters and conferences that we offer. So if you want to sign up and be part of our kind of social community, as my girls always say, send me a note. We'll put you on our distribution list, and you can access some of our materials, including our cross-border book, mainly for HR and lawyers in the US that want to understand the difference between US and Canadian law, but it's very helpful for those outside the country. We also have a book on doing business in Canada, which covers more than just labor and employment, and I'm happy to send you copies of those as well. So again, thanks for joining today. Thank you, panelists. I hope it was helpful. We got to some of your questions, and I'll turn it back over to Mondak and Dan.
Thank you very much, Tim. Yes, to finish today, thank you very much, Tim, Emily, Patrick, Jessica, and Marco for your time today. It's been a real pleasure listening to you speak today with such expertise, and I hope we can have you back again soon. Thank you also to our audience for the number of wonderful questions that we've had in. They will be passed on to our panel, who will be in touch. Thank you again for spending your time with us, and we will see you soon. Goodbye.